Hi, Mr. Smith, you have any- You let me know, okay?
I just clicked on the link that I sent her, so cool, I'll send it right now. Bye. She's in a waiting room, I don't see her. That's why I reset my computer. Dr. Party, I don't know if, did you join Zoom?
Yes, I'm here. I did the link that Mr. Noble provided me, but I don't see anybody.
Thank you. That is me, Mr. Noble, right now speaking to you. So I just, your name didn't show up. It showed up as someone else's name on the team.
Oh
So
my goodness, that's right. I'm so sorry. I filled in for somebody one time and it makes me rename myself. I will fix that.
All right, good afternoon. I'm Judge Steinloggy. This is Division 2 of the Coconino County Superior Court. This is the time set for the second half of Rule 11 hearing, contested hearing in CR 2023-00379. The court, I'll turn it over to the parties to put your appearances on the record, and then I will read the victim's rights advisory. I do believe we have I think we do have alleged victim present.
thank you, Your Honor. Daniel Noble for the state, also present on Zoom is the victim, Rachel Beliski, and then also a representative from Victim Witness Services, Mr. Harley High.
All right, thank you.
Judge Greg Parzik on behalf, I've been court ordered appointed on behalf of Mr. Smith, Adam Smith. He is present, Judge, and in custody. Judge, he's currently in the jury box. I've tried to communicate with him, of which he's refused any communication with me. If he's going to communicate with me, I'd ask that he be seated next to me so we can discuss this case. Yeah. That being said, is, at this point, he still has not communicated with me.
Good afternoon.
Good afternoon, Mr. Steinlage. I trust you are well. Did you have a nice Christmas, Mr. Steinlage?
Good afternoon, Mr. Smith. And before we proceed, the court is going to read the victim's rights advisory as required. If you're the victim of a crime with a case pending before this court, you are advised that you have rights to justice and due process under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity, to a speedy trial, and to a prompt and final conclusion of the case. You have a right to be present at court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling and sentencing, and to receive restitution from a person who's been convicted of causing your loss. If you've not already been provided with a written statement of all victims' rights, you may contact the Victim Services Division of the Prosecutor's Office to obtain one. So this is an unusual set of circumstances where I realize, Mr. Parzyk, that you've taken over the case since the first witness was called in this contested Rule 11 hearing back on June 24th. And we are now at the point where we're ready to hear from Dr. Pardee. And before we begin, I thought I'd go ahead and give you the opportunity. I didn't know if there was anything that you wanted to place on the record. I know at the last setting, it was the first time we had seen you on the case, and I wanted to make sure that you had gotten the materials that we discussed at the last setting. So I just want to give you the opportunity if there was anything that you needed to state before we begin with the
Judge,
state following the second witness.
Judge, I appreciate it. And the state has been, Mr. Noble has been very good, as has his staff, of getting me all the discovery, as has the prior counselor at the Legal Defender's Office, Ms. Marini. I've talked to Ms. Funkus at the Public Defender's Office. I talked to the counsel who, and I can't remember his name, was here for the
Mr. Tobler.
Mr. Tobler. I talked with him. I have all of the unredacted reports from both Dr. Linsky and Dr. Pardee. I have reviewed and have been provided with the testimony of Dr. Linsky. I've gone through all of that as well. Unfortunately, the only thing I have not had is any communication with Mr. Smith. I've made numerous attempts over video visit. He has blocked me. This morning, I attempted to visit him. And I don't know the court, the setup, understand what legal visit we have to do through plexiglass, and we each get to talk through a phone. Mr. Smith would not pick up the phone. You can, when you yell, you can yell back and forth through the plexiglass. I explained to him that I needed him to cooperate. If he didn't communicate with me, it makes it much more difficult. He did hold up a sign for me, but that was about it.
All right. Thank you,
And he
Mr.
provided
Pardee.
me with that sign he held up.
All right.
Judge Steinlage.
With that, are we ready to call the next witness?
The state's ready, Your Honor.
All right, let's proceed. The state may call its next witness.
Thank you, Your Honor. The state does call Dr. Deborah Pardee.
All right, Dr. Pardee, before you testify in the case, I'm going to place you under oath myself. If you'll raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, you can go ahead and put your hand down. If you'll please state your full name for the record.
Yes, it's Deborah Jean Pardee.
All right, thank you. If you'll spell your last name for the record.
Pardee.
All right, the state may proceed with its direct examination of Dr. Pardee at this time.
And thank you, Your Honor. Dr. Pardee, where do you work?
I work at the Guidance Center.
And what is your role there?
I am a psychologist.
And you're licensed in Arizona as a psychologist?
Yes,
And as your roles and duties there at the Guidance Center, are you been previously approved on a previous list approved by the court to do Rule 11 evaluations?
yes.
And have you gone through any certification to do that process?
I've attended the legal competency and restoration conferences, I think 5 times. I was asked to present there twice, so I've done it multiple times.
And how long have you been doing Rule 11 evaluations?
Since 2015.
And how long have you been practicing as a psychologist?
As a psychologist, about 14 years. I was a clinical social worker before.
And as your role as a psychologist, are you familiar with mental health disorders and the DSM?
Yes,
And what is bipolar disorder?
Bipolar disorder is a mood disorder that manifests as either a combination of depression and manic behaviors or just more of a manic state. Manic meaning extremely elevated mood, pressured speech. So there's a difference, but overall bipolar disorder is a general term that means a mood disorder that is very disruptive to the person and to others around them.
And are there any specific diagnostic criteria that you look for when looking at a patient or someone?
Yes, for bipolar disorder, well, you look, of course, historically to see when it first started to show up with bipolar disorder. It's thought that it shows up probably late teens and early 20s, sometimes full blown around age 25 or so. It's just an extreme labile mood. Um, Characterized by sustained lows and sustained highs. Some people look at it as a rapid, I'm in a good mood an hour later I'm not, but that's really not bipolar disorder. Excuse me. So bipolar disorder can be very disruptive. The person can have a very pressured speech. They don't track a conversation. They don't listen to what goes on around them. They can be very impulsive. They can stay up for days at a time. They do a variety of behaviors that are very detrimental and sometimes harmful to themselves.
And what is schizoaffective disorder bipolar type?
Schizoaffective disorder is an interesting disorder in that it can look like bipolar disorder, but it involves it involves aspects of schizophrenia with hallucinations, and there's a general deterioration in hygiene and appearance and functioning that you might not see so much with bipolar disorder. It's bipolar type is when someone has more of an elevated mood. They are not severely depressed, like what you see sometimes with schizophrenia, where people are almost in a vegetative state.
And you were appointed in a matter with Mr. Adam Smith, is that correct?
Yes, twice.
And you, so there were 2 evaluations that you did?
I'm sorry, can you repeat yourself?
So there were in fact 2 evaluations that you did?
Yes, there were 2.
And the second one, sorry, was on or about February 2024, is that right?
I did one in January, oh no, October, looking at and yes, in February of 2025, I did the second one.
Thank you. Yes, thank you. And when you met with Mr. Smith, did you have an opinion on what his mental health diagnoses were?
This second time I met with him, I thought it would either be bipolar disorder or schizoaffective disorder. It's hard to see through the plexiglass. He didn't look particularly disheveled, but his speech was extremely pressured. And so I kind of chose bipolar as the first diagnosis. But there's, you only see somebody for a very short period of time. You don't get to see them in a long period where you can actually observe their behavior.
And so in that second meeting with him in 2025, thank you for correcting me, you mentioned that there was pressured, I think, speech, and that were there any other, did you meet any of the other diagnostic criteria for bipolar disorder or schizoaffective disorder?
Well, his mood was very elevated. He was, again, having very pressured speech. He wouldn't, he just perseverated on reading this, I want to call it a manifesto or a 17-page document where he outlined all of his anger and concerns about the court system, Judge Steinlage needing to recuse himself. He was talking about the Knights of Templar and the Masonic, I think it's called Masonic Lodge, or Masons in general, the Freemasons, and he talked about the victim and how the victim had been involved with I don't know what you call it, the president or ruler of the Masons. It was very difficult to follow him, and after probably about 10 minutes, I asked him to please stop, but he didn't.
Um, and were his thoughts delusional in any way when you spoke with him?
Yeah, he has, it's very difficult to distinguish between bipolar and delusional disorder. They're not really discrete disorders. Lots of times people with bipolar disorder have fixed delusions, and we have to look at, are the delusions individual, or are they delusions that are supported, or beliefs that are supported by the segment of the population? So it's kind of hard to separate that out sometimes. But with him, his focus is on the victim's relationship with the leader of the Freemasons, and how that relates to him. And it was very fragmented. It was very difficult to follow. Talked about the Knights of Templar, but not at all related to anything that I was trying to find out from him.
And so based on those observations, did he meet the diagnostic criteria, in your opinion, for bipolar disorder and then even schizoaffective disorder, bipolar type?
Yes, I will add to that I also got information, I watched the video from his court hearing, and I also spoke with someone from the jail who has had the opportunity to observe him for a period of time, and certainly bipolar disorder seems to be probably the best choice for a diagnosis.
Okay. And would that have been medical proprietor at the jail, Summer Wolf?
Yes.
Okay. And based on your interaction with Mr. Smith, what were your concerns regarding competency?
The first time I saw him, he could talk reasonably about the roles of trial participants and courtroom procedures. This time, he just could not be redirected. He just was focused, hyper-focused on getting his thoughts across about the different things that have bothered him, the court system, I've outlined all of that previously. So it was just impossible to direct him. I also just basically, he can't possibly assist his attorney in his defense if he refuses to speak or has this presentation of being or listening to someone else talk to him. So that's why I determined that he wasn't competent.
And you also mentioned previously here today, either the delusions or discussion of those other orders. Were his thoughts, I guess, persistent discussing those?
He perseverates on those themes of the Freemasons, the Knights of Templar, the need for the judge to recuse himself. He had a document that I'm sure you're aware of, and I did look at it. It was just basically focused on those themes and the victim and the victim and participating in an empirical research, I believe, was one thing that it said. So there's just a lot of nonsensical aspects to what he was saying.
And so instead of discussing the charges or the courtroom participants, he would stick with those subjects matters instead.
Yes, he wouldn't even address what I was asking. He tends to take the lead and talk over someone.
Okay. And so basically, it sounds like he has difficulty discussing with his attorney. And so would it be that he doesn't have the rational understanding to to work with his attorney?
I believe if he chose to work with his attorney, he could. However, I want to say that he presented very differently this second time. And I recommended that he be restored and using psychotropic medication as a means of restoration because he just was very irrational the second time I saw him. And I did, as I said, review that video that the county attorney's office sent of the court hearing. I think it was in January of 2025. He presented the same way as he did in front of the court.
And how does his presentation, as you described it, affect his ability to make decisions in his case?
I would suspect that he has a psychiatric disorder that can be treated with medication, but right now it doesn't sound like he's cooperating with his latest attorney. And I don't know that he's been cooperative with other attorneys. I think there's been about 5 or 6 of them. So am I answering your question?
And I think you answered a different question that I was going to ask, but how did it affect? So that's kind of how he works with his counsel, but how does it affect him, his ability to make a decision himself in his case?
I don't know that I can answer that because I would suspect that the thought disorder, the symptoms that he has interfere with effective decision making.
Okay. And did you have any concerns about his ability to, based on his presentation that you saw him, his behavior that could be, would that affect his ability in court?
Yes, oh dear. Can you please repeat your question?
Yeah, and so based when you saw Mr. Smith and how he presented that day, would it affect his ability to control courtroom behavior?
Well, obviously, the last time I saw him on that video in court, he could not control his behavior. I don't know. I guess what I'm saying is that I don't have data to show how he is when he's not in the spotlight. And information from people who see him on a daily basis would be very helpful. And that's why I consulted with Summer Wolf, who told me that it acts in a pretty similar manner to what I observed. And that he also, in her words, instigates a lot of trouble on the unit or the pod. So given that type of behavior, it's unlikely that he can effectively or appropriately conduct himself in the courtroom.
In your most recent visit with Mr. Smith, were you able to talk about any of the legal issues or defenses or anything like that?
No.
And what did the conversation consist of instead?
He was trying to read his 17-page document, which just involved the Knights of Templar, Masons, as I said earlier, those themes that I mentioned earlier.
And then also, so you mentioned that you saw him in February 2025, but then also in October, and you can correct me if that's the wrong month, but I think it was 2023. Is that right?
Yes.
And in October 2023, you found that he was competent at that time. Is that correct?
Yes, he responded to questions. You know, he was focused on the devaccinator that he invented and wanting to tell the world about the danger of the COVID vaccine. However, he also answered questions about courtroom procedures, roles of trial participants. He came across as much less pressured than he did this second time. And he just presented as someone who could work with his attorney, and I believe I used the word, should he choose to work with his attorney. I thought he was competent to do that at that time.
Okay. You mentioned that, so he was much less pressured in 2023. What other observations did you notice that changed between 2023 and the second evaluation in 2025?
Well, his speech was just much more pressured the second time, and he was very focused on delivering this information to me and not listening or responding to the purpose of the Rule 11 evaluation. I explained to people early on when in the beginning, when I conduct these evaluations, what the purpose is, what we're trying to find out. I explained it very clearly. Mr. Smith this time around was very prepared when he saw me. He had read my previous report. He called me by my first name. It was just a very interesting, as I say, he likes to take over the interview. He likes to put himself out there first. So I explained, I had a student with me this time. He said she could sit in unless she was a member of the Freemasons or Knights of Templar, which my student didn't know even what that meant. So she was obviously answered in a way that allowed him to allow her to be there. And then it just went into the 17 pages that he wanted to read aloud to me.
And so you saw him in 2023, 2025, and did you ever meet with Mr. Smith again?
No,
I know you wrote a report a long time ago, and sometimes doctors do follow-up. Did you do any follow-up since your second evaluation in 2025?
I didn't see him. I wasn't asked by the court to see him. I do from time to time inquire about him through Summer Wolf, and she basically believes that he has bipolar disorder as well, and she has the advantage of getting information on his behavior and his mood on a daily basis.
Judge, I'm going to object to Summer Wolf's opinion of what Mr. Smith may or may not suffer from. I know hearsay is admissible, but I believe we're venturing into a diagnosis that I would ask the court to, I would object and ask the court to strike and not consider.
All right. Does the state wish to be heard?
And Your Honor, it's just information that she's considering. So she also considers Dr. Alinsky's evaluation and his opinion as well. I think it's appropriate that and the court can take into consideration that it is hearsay in a separate diagnosis.
The court will allow the witness to testify as to all the information that she's taken in, particularly in light of the fact that her time spent with Mr. Smith in this most recent interview, as I understand it, was very abbreviated based upon his own actions during the course of that interview. Although the court will just note, I'm not putting any weight on it in terms of making my determination. I'm only allowing it in as it informed Dr. Party's ultimate opinion.
And did that follow-up discussion with Summer Wolf change your opinion of Mr. Smith's diagnosis in any way?
No,
Did that affect your opinion regarding his competency in any way?
no, it remained the same.
And it was basically that he was not competent?
Not competent, but restorable.
And you say restorable. Typically, how are these two disorders treated?
With medication, psychotropic medication.
And those are typically successful in your understanding?
Yes.
Based on your knowledge and investigation, in this case through the jail, do you know if he took any medications?
He has not been receptive to medication ever, as far as I know.
And based on his condition and desire to not want to take medications, what facility would you recommend sending Mr. Smith to?
I made two recommendations, one to the RTC program at the Camp Verde Jail and then the state hospital. I don't know if he would be accepted at the state hospital, but definitely the RTC program would be appropriate.
And do you think possibly that because of his refusal to take medications, that a cell hearing may be appropriate in the future?
I think that that may happen and it would be appropriate, yes.
Okay. Um, And it's your opinion that either through the Arizona State Hospital or the Camp Verde Restoration Program in Yavapai County, that he would be restored to competency in the statutory timeframe?
I think if he was compliant with medication or if the medication was ordered, I would think he would become competent. I can't predict, but it seems based on he's very intelligent. He understands concepts. It's just that his flight of ideas and this his just obsession about the topics I outlined before really preclude him from becoming competent or presenting in a competent way.
Thank you, Doctor. I have no additional questions at this time.
All right, thank you. Cross-examination, Mr. Parzik.
Thank you, Judge. Dr. Party?
Judge Steinlage, I wish to invoke my right to self-representation and my right to face my accuser. Good afternoon, Dr. Party. How are you doing?
I'm fine, Mr. Smith.
I'm sorry.
Did you
Dr.
say-
Party, Mr. Smith will not be conducting a cross-examination of you. If you'll just wait a moment. The court, because Mr. Smith is currently in Rule 11 proceedings, the court has explained to him previously in writing that the court cannot allow him to represent himself while he's undergoing Rule 11 proceedings. So at this time, Mr. Parzik, Mr. Smith,
Questions for Ms. Party, please, Mr. Steinlage.
no. The court, up to this point, you've done a good job of maintaining your composure during the course of the hearing.
Thank you.
I'd like to have you continue to stay, but you won't be conducting the cross-examination. I can't allow you to invoke your right to represent yourself at this point. The court is not going to argue with you. So I would like to have you stay here, but if you can't continue to control yourself, I'll simply just have to have you removed from the courtroom. So
But I wish to ask the questions, and I have questions.
you may not. So, Mr. Parzik, at this time, if you'll proceed with your cross-examination.
Thank you, Your Honor.
Cross-examination of my own accuser, please, Mr. Steinlage.
Dr. Party?
Yes,
Authority.
My understanding-
The authority of Big Brothers Big Sisters, Mr. Steinlage.
it's hard for me to hear you, sir. There's talking in the background.
Again, Mr. Smith's behavior in the courtroom is preventing the court from being able to conduct the proceedings. So at this time, I'm just going to ask the officers to remove him from the courtroom.
How may I meaningfully participate in my own defense, Mr. Steinlage? Did she say Knights Templar, or did I say Ordo Templi Orientis, Mr. Steinlage? Did I say Ordo Templi Orientis, or did I say Knights of Templar? Let's go. Had a motion of Rachel Poleski gave her consent. Why did you bury that down, Rachel? You buried that down.
All right, so we'll proceed with cross-examination. It's unfortunate. The court obviously would prefer for Mr. Smith to be able to remain in the courtroom, but it's just not possible.
Judge, I would make a request with regard to the situation. Obviously, Mr. Smith's conduct required what just occurred. However, there's an opportunity, and you know this more than, I mean, everybody knows this. Mr. Smith has been very active and wants to be very active in his case. There is a possibility of Mr. Smith being able to watch and listen to these proceedings through a video visit while still on mute. I would make the request, and I think in a situation like this, where a defendant has a constitutional right to be present at a proceeding, but conducts himself where he no longer can be present, I think the court, and I think there's a constitutional duty to do the least restrictive means of his non-presence, and that can be done with him through the video visitation or the video system through the jail, where he can still watch and listen, but he can be muted. I know this may delay things, but Judge, I believe constitutionally that may be best way to proceed, and I would request that.
I'm going to deny the request today. I think it's a great idea for the future, and it's something that I would certainly welcome and try to do. I'm not going to bifurcate the hearing yet again and stop the hearing at this point. The court, it's taken over 6 months to get to the second half, and you're the third attorney that's been on the case since the last setting. So I believe that's a good idea. That's essentially kind of what we had at the last setting, since you were appearing by Zoom, and the court would welcome that in the future. But today, the court is going to proceed.
And Judge, so it's clear you are ordering me to proceed today.
Yes.
Okay. Dr. Pardee, it's your opinion that Mr. Smith is incompetent, correct?
Yes,
I just want to kind of go through the definition of incompetence with you and make sure I understand exactly what you're saying. Is that okay?
yes,
My understanding in reading the definition of incompetence is that incompetence means a defendant is unable to understand the nature and objective of the proceedings. And then there's an or. Let me stop there. Do you believe Mr. Smith is able to understand the nature and objective of the proceedings?
I think he's able to understand it. He didn't present that way the second time I saw him.
But the first time you saw him, you indicated that he understands the proceedings and is very intelligent, correct?
He is very intelligent, and he certainly does understand the roles of trial participants as well as basic courtroom proceedings, yes.
And you have no information that indicates that at least that portion has changed in the second meeting.
I don't know. I would say probably not, but I can't say for certain.
Okay, so then let's get to the second prong, and that is that he, again, means the defendant is unable to understand the nature and objective of the proceedings. Here's the second prong, or to assist in his or her defense. My understanding is you don't believe he's able to do that at this point, correct?
Yes, I don't see him collaborating with you or any of the other attorneys that he had before.
And you've said that a number of times, but let me ask you this. You understand Mr. Smith wants to represent himself, correct?
I didn't know that until just now.
So your basis of the fact that he would not be able to assist in his or his defense is because he wouldn't be able to collaborate with his attorneys, correct?
Yes, that's the second prong of the statute that I look at as well.
But if he represents himself, there's no need to collaborate with anybody, any attorney. Would you agree with that?
Yes,
All right. The final prong is that he has a mental illness, defect, or disability. Correct?
yes,
And my understanding is that you believe he has been, or you diagnose him with bipolar disorder.
yes,
And that is based on the diagnostic criteria in the DSM-5.
the DSM-5 text revision, DSM-5 TR.
Okay, so the DSM-5 TR. And can you tell us specifically, do you have that DSM-5 TR in front of you?
I might. I'm going to mute.
Do you know? Oh,
Dr. Pardee, your video and audio just turned off. If you could turn that back on for us.
Yes, I just moved into my new office, and I didn't want you to see all my attempts to discover. I don't find my my DSM manual, I'm sorry.
Do you have the specific criteria that, that Mr. Smith meets for the diagnosis under the DSM-5 TR for bipolar disorder?
I don't have the DSM-5 criterion right in front of me, but I will tell you what caused me to formulate that opinion. His speech was very pressured. He had what we call flight of ideas. He was tangential. He wouldn't focus on the conversation that I was attempting to have. He did understand the purpose of the Rule 11 evaluation. He persisted in discussing or trying to present some delusional thoughts. Now, and I will go back on that in that there is a segment of the population that believes some of the things that he believes about the COVID vaccine. So we try to separate that out. This time around, what I noticed was just a heightened, kind of frantic speech and just unable to slow himself down. And that really was different from the first time. And again, when I saw the video that the county attorney's office provided, it was the same type of behavior that I saw when I saw him the second time.
Okay, and I
You're-
understand that, I understand that, Doctor. I was just specifically asking for the specific criteria that you believe under the DSM-5 TR existed that he meets the bipolar disorder diagnosis. That's all.
Yes, pressured speech, flight of ideas, tangential thinking, unable to focus on the topic at hand, kind of a grandiosity. I've invented this thing and I have to tell the world about it. It's hard to see people in terms of how they would move around because they're tethered to the telephone. But sometimes with bipolar disorder, you'll see a lot of what we call psychomotor agitation, moving around and, odd hand gestures. I didn't see that so much, but again, he was on the phone. But those are the criterion that I looked at.
Can we talk a little bit about that? So you saw him through basically a legal visitation at the jail. Would that be accurate?
Yes,
And that was through the plexiglass glass
yes,
where he's on one side with a phone
yes,
and you're on the other side with a phone.
yes,
And basically he's seated and you're seated, correct?
yes.
And you're able to see, well, depending on the glass, if you're both seated, you can only see the person from the chest up, correct, through the glass?
Yes, unless they're sitting back, and I think he was visible from the waist up.
Were you, and my understanding, this second visit lasted about a half hour?
Yes,
The first visit, did that occur the same way through the legal visit through plexiglass?
yes,
Okay. And are you aware, or is there the ability to see somebody at the jail, what's called a contact visit, where they're not through plexiglass if you make a request?
I have only made that request a couple of times, and it's under special circumstances, and Commander Figueroa has to approve it.
But that can be done, correct?
It's hard to do. I don't know if they would allow me to do that in this case. They have in a couple of difficult cases.
Did you
but
make that request? Did you make that request in this case?
I did not.
The second diagnosis you indicated was schizoaffective disorder, correct?
Yeah, yes.
And it's your opinion that he suffers from that disorder as well, correct?
I said that bipolar versus schizoaffective disorder. And as I said earlier, just to clarify, it's very difficult to make a diagnosis when you see somebody for a brief period of time. Um, I, I will say, just as an aside, that Yavapai County, for example, allows evaluators to see the jail record. So we can see through a period of time how this inmate interacts with other staff. Do they present as they did during the session with the evaluator, it's very helpful to see just what happens over a period of time.
Doctor, let me ask you
Schizoaffective,
this,
I'm so sorry, go ahead.
if I may. I just want to get, can you specifically tell us what were the specific criteria pursuant to the DSM-5 TR that you found, and just list them, please, with regard to your second evaluation that you came to the schizoaffective disorder?
I said first is schizoaffective disorder, which means that we need more information, but bipolar type mood symptoms, mood, elevated mood, just kind of a manic presentation, can't stop talking, can't listen. There's a paranoia. Were delusions about the COVID vaccine, about the victim, about the Masons and the Knights of Templar. Sometimes with schizoaffective disorder, or more often we'll see hallucinations or a history of hallucinations. I could not determine that. But when I write a diagnosis like that, what I'm really looking at is I don't know for sure. We have to have more information.
All
So
right, so let me ask you this. You
Yes.
believe for sure he suffers from bipolar disorder,
he has symptoms of bipolar disorder.
but you don't know for sure of schizoaffective disorder.
I don't know for sure.
That's all I have. Thank you.
And redirect?
And thank you, Your Honor. Just, I think, 1 or 2 points. And so, Dr. Pardee, you mentioned on cross-examination, Mr. Parzik discussed his ability to discuss with his attorney. However, in your discussion with Mr. Smith's case, was he able to talk about the facts of the case, or is it more on towards tangential issues?
During the second evaluation, he didn't talk about the case except to talk about Judge Steinlage needing to recuse himself, wanting to go to federal court, wanting to move his case forward to a different court. And again, the Masons and the Knights of Templar.
Okay. And so he was, and I'm not asking for a specific statement in this matter, but he wasn't able to provide any defense or discuss defenses with you then?
No, he did not discuss any of that. He would not stop talking the entire time about the topics that he wanted to present to me.
Okay. Nothing else. No additional questions. Thank you.
All right, thank you. Is that all of the state's witnesses?
Yes, Your Honor.
All right. Previously, prior to being on the case, Mr. Parzik, as I'm sure you're aware, the court had previously authorized some funds to, it was Mr. Tobler at the time that was representing Mr. Smith for Dr. Wayne General. I authorized those monies under Rule 6.7 for general defense, or, but understood at the time that Mr. Tobler may wish to have Mr. Smith have. Oh, I'm sorry. I should have addressed Dr. Pardee. I know she's busy. Can I excuse Dr. Pardee?
Yes, Your Honor.
No objection.
All right, you're excused, Dr. Pardee. Sorry about that.
Thank
Once
you,
I saw
Your
it on
Honor.
my screen right in front of me again, I remembered I hadn't done that. I apologize.
Thank you.
And it was my understanding from Mr. Tobler at our setting back in June that whatever they were working with on that money through the legal defender's office, that they had no intention to present anything to the court as part of the Rule 11 proceedings. So I wanted to just make sure that you are aware of that sequence, and that you, in your situation now, aren't in disagreement with that.
I'm aware of that situation. I've had discussions regarding that situation.
Okay, thank you very, very much. So with that, are there no witnesses for the defense?
No, Your Honor.
All right. In that case, we'll proceed to argument in the matter, and I'll turn it over to you, Mr. Noble.
And thank you, Your Honor. There are 2 separate evaluations done with Mr. Smith recently that show that He is not competent but restorable. The state does ask the court to adopt the determinations by both Dr. Linsky and Dr. Pardee. There is a mental health disorder in both of them. Dr. Linsky found delusional disorder, and he found that is much more entrenched now, I think was his terminology back in 2025 than it was back in 2023. And it's much more prohibiting him working with his attorney, working and making rational decisions in his case because of that. And similarly, Dr. Pardee's report and testimony here today is very similar to that, is that he has become much worse, or I think as she described his speech is much more pressured and cannot get a word in edgewise in order to discuss the facts of the case, possible defenses, or even making rational decisions in his case. She has a separate diagnosis. I think bipolar disorder is her primary diagnosis, and then also concerns that it could be schizoaffective disorder with bipolar type. But each of those meet the criteria here, and also affecting him to make a rational understanding in his case to make a decision. So the state does ask that the court adopt their determinations and find that he is not competent, but that he is restorable in the statutory timeframe as both doctors provided. And so in that this condition is medication dependent and very likely can be treated with medication. So the state does ask the court to find that he is likely restorable within the statutory timeframe. The state does recommend that he go to the Yavapai Restoration Treatment Facility because of, I know that it seems like it's likely that since he is refusing medication, a cell hearing could potentially be needed. And I know that they do in fact do that. And so that is the state's recommendation here. Thank you.
All right, thank you. Mr. Parsons.
Dan Noble admitted in the June 24th hearing, Deborah Pardee had a conflict of interest and had been requesting.
That was one of the onlookers on Zoom. So, Mr. Parzak, go ahead.
Thank you, Judge. Before I begin my argument, I just want to indicate that before I do Rule 11 proceedings like this, I reread Bishop v. Superior Court, County of Pima, 150, Arizona 404, and just some quotes from it, Judge, that's going to explain my argument. And what Bishop does is talks about the role of defense counsel in competency proceedings, and I'm quoting, we think it obvious also that the role of defense counsel at a competency hearing is different from the role of defense counsel at other proceedings. I'm jumping ahead here. Defense counsel has a responsibility for the court for the correct determination of competency issue that he does not have with respect to other issues. Although it is the court's responsibility to determine the issue of competency, counsel has the obligation flowing from his duty to protect his client's rights to see that the issue is decided correctly. As with the question of raising competency issue, counsel is not free to chart an adversary course at the hearing based on his view of his client's best interests. My role at this hearing is to make sure you get it right. As an attorney for 33 years, doing nothing but defense work, it's hard for me to change from that advocacy to the role in competency. But I do acknowledge the Supreme Court has told me that is what my role is. So my job here is to make sure you get it right. That being said, Judge, unfortunately, I have not had the opportunity to have any communication with Mr. Smith at all. Part of what Bishop says is I'm probably the best witness to give the court and others information as to where we are. I don't have that. In fact, quite frankly, the court has more information than I do. That being said, it is crystal clear to me that Mr. Smith adamantly wants to represent himself. I understand we have different diagnosis. I, again, listened to Dr. Linsky's testimony, and he indicated that there is a delusion disorder. Obviously, Dr. Pardee indicates that I'm just going to stick with bipolar disorder because I don't know if she really gave it schizoaffective disorder, but that they are different disorders. I think both, and I listened specifically to Linsky's testimony about this, and he indicated, and I can give you the date and time, or the timestamp on it, but even in the second, Dr. Linsky believed that Mr. Smith still understands the nature of the proceedings and the objective of the proceedings. I know Dr. Pardee did not, because there apparently wasn't that opportunity. And that may have been via Smith's own actions. I get that. That being said, is where we really are is the ability to assist in his or own defenses from everything I've reviewed. And obviously, I believe I'm number 6 in the line of defense counsels. Mr. Smith has already filed a bar complaint against me. I anticipated, I knew that was coming. I think when the court does look at whether he's competent or not, the court does have to consider that he may not be able to assist with his defense attorney, but that's because he doesn't want one. He wants to represent himself. Will there be problems in the court? Certainly. We just saw one and I've seen them in the past, but that's something this court can deal with, as it just did, by either having him removed from the courtroom or allowing him to come in or Zoom in where he's muted. I think that can be dealt with differently. With regard to competency, Judge, well, quite frankly, there's a competent to proceed with trial, incompetent to represent oneself. Again, I read the case law on this. They seem to equate in Arizona, although there's something called the gray area that courts have dealt with. I don't think we need to get to that. But in this case, Judge, I do believe that there's been no showing that Mr. Smith cannot competently represent himself. May he say things that we disagree with, or may he go off topic or get into irrelevant issues? Absolutely. But again, this court has the ability under the rules of evidence and, quite frankly, the ability to control courtroom decorum to take care of it. So based on that, I would ask the court to consider that in determining whether or not Mr. Smith is incompetent, and find out at this point, at least if he represents himself, he still can be competent. That's all I have. Thank you.
All right, thank you. Anything further from the state?
And just briefly, Your Honor, there have been several hearings that Mr. Smith has not been able to be present because of his behavior in court. Additionally, or muting Zoom, so because of the comments that he was making, it's clear that he doesn't have a rational understanding because of his mental health diagnoses, and so therefore cannot present a defense or cannot present information to counsel or a jury or the court in order to provide that argument. And so because of that, the state does ask the court to adopt the findings of Dr. Linsky and Dr. Pardee because he doesn't have that rational understanding in order to present those topics to those who need it. Thank you.
All right, thank you. At the outset, I just want to thank you, Mr. Parzik, for your reference of Bishop. I think that your professionalism and focus on what your role is here is well taken. Frankly, I wish that all of the attorneys that were sitting there in your position and a lot of the Rule 11 hearings that I have understood that distinction as well. I don't know that everyone is tuned into that difference in role, and I certainly appreciate that. I'll also just at the outset just offer that I recognize Mr. Smith wishes to represent himself. There's no doubt about that. He has filed, I don't know how many waivers of his right to counsel and assertions that he wishes to represent himself. And the court, if in a position at some point in the future where I can honor that, that's very much what I would like to see for him if he has the ability to do that. As you know, I know that you were sitting in my court as just during the previous setting, and the court was working with the self-represented litigant who incidentally had also gone through these proceedings and is currently representing themselves. So it's something that the court would like to see from Mr. Smith. I have incredible difficulty picturing that at the present time, but the court wishes to honor that and give him the opportunity to do so when the court is in a position to do that for him. You're certainly welcome to communicate that to him since he's not here. That isn't something that the court's resistant to, and it's something that the court actually does oversee in cases like this in other matters. In making my decisions here today, the court, of course, I should just note that I've reviewed all 4 of the evaluations that have been generated and submitted to the court in the case, including the original report that was done by Dr. Linsky initially back based upon what was filed with the court on October 16th of 2023. I also reviewed the report from the evaluation by Dr. Pardee that was submitted to the court back on November 10th of 2023. Those are the dates that the Guidance Center submitted the respective reports. The court also reviewed the third evaluation that occurred based upon the court's own motion, based upon Mr. Smith's inability to control himself during court proceedings. I ordered that on my own accord last year on October 14th of 2025, based upon the uncontrolled outbursts and inability to behave appropriate just during a simple case management conference, I think it was, during my regular law and motion calendar. The court got that report from Dr. Pardee, where she made her recommendation, her opinion that Mr. Smith is not competent, but likely restorable within the statutory timeframe. That was filed with the court by the Guidance Center on February 24th of 2025. And then lastly, and most recently,
Adam Smith was
there
convicted
was
in
an
Washington State. That is a
evaluation
lie.
by Dr. Linsky on, and that was at the request of defense counsel to have an additional evaluation completed. And that was filed with the court by Dr. Linsky on by the Guidance Center on April 22nd of 2025. The court would note that both the first two evaluations came back with recommendation or opinions of Mr. Smith being competent at the time, and then the two more recent evaluations by both doctors ultimately opine that he's not competent and likely restorable within the statutory timeframe. The court also went back to the original, or I guess the first half of this hearing that we're still at here today, from June 24th of 2025, in which Dr. Linsky testified. I do want to just reference back to some of those determinations, as Dr. Linsky described Mr. Smith having a delusional disorder that did have symptoms of psychosis, which he described as being unique because he doesn't observe that there's any auditory or visual hallucinations that are being experienced by Mr. Smith, but he has tremendous suspicious and paranoid features, as he testified to. He also testified to his observation of the fixed false delusions that had occurred over the time period that's required in two different realms for determination of those delusions. Dr. Linsky made reference to over the time that he had passed between his first and second evaluation of Mr. Smith, that Mr. Smith's intensity of his belief system had increased significantly, and that in his view at that point had become disconnected from reality. And he noted that Mr. Smith had become unable to challenge, and that was one of the features that made it clear to him that it was delusional, because you just couldn't rationally talk to him in any meaningful way, in any way that challenged any of the things that he expressed as his beliefs. He indicated that the beliefs had been crystallized into a set of unique beliefs that were all about himself. He testified about Mr. Smith's beliefs in the COVID vaccine making you non-human, and that the Masons were stopping this information from getting out for some reason, and that he believed that he'd be killed if he was left in the jail, but then that he also believed that jail provided him with a platform of some sort to put that information out there. I can't rationalize that and understand that, but um, he just noted that these delusions were just clearly not rooted in reality and were just clearly false at this point, which was a difference from the way he saw Mr. Smith's beliefs when he initially did a Rule 11 evaluation with him in 2023, which at that time he recognized that Mr. Smith's beliefs were, you know, there are people still out there that believe in those similar beliefs, but they, at this point, were so rooted that it had become an actual structure of delusion for him. And with the delusional disorder, Dr. Linsky noted that typically it does require medications to increase a person's dopamine and sometimes antipsychotic medications. He noted that there was a possibility that there could be a personality disorder at play here, similar to what I believe Dr. Pardee was trying to refer to as well. That's something that, and I'm just aware of it from my time on the bench as well. It's a much harder thing to diagnose because of the time that's required to observe a person to actually make a determination that they have a personality disorder. It's something that really can't appropriately be diagnosed without somebody repeatedly seeing a person and takes a lot of time. And that's not what occurs during these Rule 11 evaluations. And both doctors acknowledged that. Ultimately, Dr. Linsky testified that he doesn't believe that Mr. Smith is competent to work with an attorney, and that he just has that he has rational deficiencies that prevent him from doing so. The court believes that those rational deficiencies that make him not competent to work with an attorney also make it impossible for him to represent himself at this time as well. And the court, respecting Mr. Smith's desire to represent himself and the argument made by defense counsel, the court believes that that also prevents him from being able to competently work on his own behalf as well. I cannot imagine a set of circumstances where the court could conduct a trial and have Mr. Smith representing himself in his present state, where he could possibly effectively do that job in any kind of rational way. The court hopes that changes and that he can be allowed to go forward representing himself in the future, but the court certainly doesn't believe that that's the case at this time. The court notes that both doctors have testified that they believe that they don't believe that Mr. Smith will take any medications without a court order. But the court also notes that none have been prescribed to him because of his refusals up front. That very well may be the case. The court, however, I know and previous counsel have expressed to the court that being forcibly medicated is, I believe Mr. Tobler described it as the worst thing that Mr. Smith can imagine. It was his description previously. It's not something, and I've tried to assure Mr. Smith that at this stage that isn't a question that's before the court. It may be something that the court has to go into a cell hearing if he isn't able to be restored without medication going forward. But it's not something that the court's going to order him to do today. There hasn't been a specific regimen of medications recommended by a doctor that have been refused by him, at least nothing that's been presented to the court. The court typically won't conduct or order anything like that unless at the restoration program. The defendant has refused to participate in that way, and then we're at a hearing and I hear medical testimony as to why that is appropriate for this specific person. What are the thoughts that have gone into that recommended prescription, and the court. I know Mr. Noble knows this. I don't think I've ever actually had Mr. Parzik on a Rule 11 case, but I issue very specific orders with very specific ranges of medications that are authorized by the court when we're in that situation. And when I get the testimony, I even will issue a specific sequence of possibilities if the doctors offer what they would like to try. And some of the doctors are incredibly thoughtful in terms of their recommendations to avoid side effects and things of that nature. And the court takes all that into consideration. That's not something I have any intention of doing here today, just that again, won't be part of my orders. And if you want to convey that to Mr. Smith, I realize it's, if you get the opportunity, and you might not, but that's something I would have certainly communicated to him today if he were here in front of me still. The court, in terms of Dr. Pardee's testimony, her testimony also in her diagnosis of bipolar disorder, in terms of the impact that it has on Mr. Smith, the court notes that it certainly affects the quality of his relationship and ability to work with defense counsel. At times during Mr. Smith's case, he has been able to work with counsel and expressed trust in some of his attorneys, and for some periods of time had relationships with attorneys. At this point, he has gotten to the point where he files bar complaints before he even ever talks to the attorney, things that just absolutely prevent him from having any kind of quality relationship with any attorney. Even if he disagrees with the attorney representing him, he doesn't even have the capacity to just have a ordinary conversation and just say, I don't want you doing this for me, or anything, as I gather. The court believes, and Dr. Pardee expressed the same as well, that perhaps the most serious issue here is Mr. Pardee's ability, his decision-making ability is so seriously affected by his delusions that it gets in the way of any kind of rational decision-making or rational behaviors in the courtroom. Lastly, his ability to control himself in the courtroom, it's a very serious issue. If the court were to, as you noted, there's a separate determination the court has to make regarding his ability to represent himself. The court has to believe that he has the ability to do that. The court sees it as a little bit different determination than just whether or not he's competent. If a person's behaviors are such that they have to be removed from the courtroom, they obviously have no ability to represent themselves. And that has been repeatedly the issue that's been confronted by the court. And I had hoped when Mr. Smith was here with us for the state's questioning that he would be able to continue on, because frankly, I agree with defense counsel. I want him to see everything, and I would in the future, if he's going to have to be removed from the courtroom, would like to set things up as has been done in the past, where he at least can see what's happening. I have no desire to prevent him from being able to observe the case, even if his behaviors are such that he can't be present in the courtroom. The court does ultimately agree with both of the doctors at this stage that Mr. Smith is not competent and able to either assist assist his attorney going forward in the defense. I also don't believe that he's competent to represent himself. Further, I don't believe that he has, I believe that his rational deficiencies, clearly he understands the factual aspects of his case, but the rational deficiencies, I believe, are a serious impediment to his ability in terms of decision-making, and then, of course, his control and able to behave in the courtroom is a very serious issue as well. All of those lead the court to conclude that he's not competent. I do accept the opinions of each of the doctors and there's been no clear and convincing evidence presented to the court that he couldn't be restored to competency within the statutory timeframe. So the court does make that finding pursuant to Rule 11.5B2A. I should have noted that the court's determination that he's incompetent is pursuant to ARS 13-5410 and Rule 11.5B2. The court does find that the defendant clearly suffers from a mental disorder, and while the court also, just as the doctors observe, it's difficult to determine exactly what that is in the time that's allotted to them, but the defendant is clearly in need of treatment and does have.
Steinlager, you were guilty of holding Adam without charge from the 15th of December.
Finds that the confinement is necessary for treatment and that the defendant is in custody treatment, that he is a threat to public safety pursuant to ARS 13-5412D, and the court is going to order that Mr. Smith participate in the Yavapai Restoration to Competency Program. The court finds that the defendant is not competent to refuse treatment and shall be subject to involuntary treatment, except the defendant shall not be subject to being treated being involuntarily medicated as a component of his competency restoration treatment, as no hearing has been requested or held pursuant to Cell versus United States at this time. The court will issue orders with further directives in terms of transport and other reiterations of the same that I've gone over, and then directives pursuant to the statutes as to providing the court with periodic reports and a final report, or any whatever they may generate. At this time, I don't have anything other than that for the parties, unless either of the parties had anything for the court.
Nothing from the state.
Judge, could the court, assuming the court is ordering me to continue representing him throughout this proceeding, I would ask that the minute entry reflect that once again there's a court order
Yes.
appointing me. And secondly, anticipating at some point we will get to a cell hearing, I will once again request a court order making sure that I'm appointed for that hearing. And I would, and I think the court already acknowledged it, and we may have a status beforehand, but I would ask that especially that hearing, that I know Mr. Smith will want to be in court in person, but if I cannot go forward, that at that point, I will probably have a much stronger objection of going forward without that ability for him to at least see and observe what already predicts that may happen, but I'm going to be pretty firm on that one.
No, and
I think
it's a great idea.
I become an advocate again. As the court knows, it's clear and convincing evidence, and we all know Mr. Smith does not want medication. So I think the court already acknowledged it, but it's something I want to just prepare the parties for.
I think it's a great idea, and if we just plan for that, I think that we should be able to have a solution in place at the outset of the program or the hearing, and the court would be
You are guilty of kidnapping Adam Smith. Now you're forced medication
arrangements. for that purpose.
It may be where we
You
break
held
free.
Adam without charge for 5 days.
Yes. So at this point, the court will just order as requested that the minute entry reflect and that you continue to represent, that Mr. Parzik continue to represent Mr. Smith throughout the Rule 11 proceedings in the case, including if there is a cell hearing requested by the state in the future. If the state, if we receive a final report that reflects that that's necessary, the state doesn't have to wait until we have a status conference upon the final report to make that request. I know that that often is the way things go, but I think that's often because people just haven't had a chance to take a look at things. So if you want to make that request proactively upon receiving the final report, and then arrangements could start to be made to get the respective witnesses, that could at least, at least decrease one delay for the sake of Mr. Smith. Anything else from either counsel?
No, Your Honor.
No, Your Honor. Thank you, Judge.
All right, thank you. We are adjourned.
Motherfucker, this is the biggest fast and fucking legal history I've ever seen. Uploading this to the cloud now.